Good afternoon, everybody. Happy New Year. We have made it to 2021, although I think that's a little consolation given the current circumstances, a bit of a shambolic start to the new year, but we hope that you're coping. And we hope that this is 15 minutes of respite for you, whether that's from work emails or being able to close the door on the kids or whatever. We hope this is 15 minutes of light relief in some way. So we're kicking off 2021 with a new kind of mini series within the Stewarts Soundbites series. And we've gone back to basics a little bit. So this is a guide to catastrophic injury litigation and the process, really, the real focus on the process and how it works. And you know, we thought about this in quite a lot of detail, and I think, I don't know whether you agree with me, Dan, but I think we take it for granted a lot of the time as claimant lawyers that all of the people involved in the case understand the litigation process perfectly, and that all cases run to the same sort of timetable, which is absolutely not the case, as we know, because every case is so different. The injuries that we deal with are so complex and the needs are so discrete that it changes so much. That being said, there is a pattern to these cases. There is a structure, generally speaking, and we thought it would be interesting to reflect on that a little bit from the claimant lawyer's perspective. So we are very lucky today because we have a much sought after speaker with us. We've got Dan Herman, who is a partner in the PI team at Stewarts and the head of the Leeds office. Dan is an extremely experienced litigator. He doesn't need any introduction. I don't even know why I'm doing this, Dan, because everyone who's watching will know who you are. But Dan's going to speak to us today as to kick off this mini-series. It's the first part. There are 4 parts in total. The first 3 will deal with the litigation process from the claimant lawyer's perspective, and the final episode will look at that process from the client's perspective. And that's going to be held at the end of the month, and Chris Smith's going to host that, and that's going to be a really interesting session too. But to kick us off, Dan's going to start today, and we're going to talk a wee bit about those initial stages, meeting the client, thinking about immediate needs, looking at case manager and getting a team set up, all those initial kind of really worrying times for clients that find themselves in a position that they never imagined they would be in. So that's a really long introduction, Dan. That's more than I intended to say. Actually, we've only got 15 minutes as usual. If anyone has any questions, pop them in the Q&A box. And if we don't get round to answering them during this session, then we'll pick them up afterwards and come back to you by email. But Dan, I'm going to kick off I'm going to dive right in and ask you your first question, which is when you go to meet a client for the first time, whether that's in the hospital or at home, and assuming that they already will assume for these purposes that they want to use the firm, what are the most common questions? What are the most worrying and concerns that clients normally have from the outset? What are they worried about initially?
Yeah. Hi, everyone. First thing to say is that there'll be very little law today. It's all going to be about the sort of the practical aspects of running cases, the sort of the nitty-gritty rather than any legal fine points. So, Emma, to answer your question, I mean, there are lots of things that clients are concerned about. Oftentimes at that initial meeting, I get asked the same 3 big questions, and they're usually the questions that I can't answer. And they are, am I going to win my case? How long is it going to take? How much am I going to get? And they're the 3 questions which are most difficult to answer at that very, very early stage, perhaps when you haven't got any evidence. You might not even have taken the client's version of events at that stage. So they're the really tricky questions. But they're the things that the clients are understandably concerned about as they embark on this process, which they soon find out is going to be quite a lengthy process. From my point of view, there are lots of different things which I'm looking to achieve at that first meeting. The first thing, perhaps the most important thing, is to get to know the client, to understand not just the nature of the injuries they sustain, but to understand what makes them tick. What were their circumstances before the accident? What are their circumstances now? How long are they likely to be in hospital for? What further treatment do they require? Are they going to go on to some other form of rehab afterwards? What are their goals? What are their hopes? What are their fears? That's it's really important as a claimant solicitor to get to grips with that at that very first meeting, really, because you can't really make progress until you've got an understanding of that. I think in parallel, you've got to explain the process to the client. Usually the clients that we meet with haven't been through this process before. They may never have met a solicitor before outside of doing their conveyancing or perhaps sorting their wills out. So they probably have very little understanding of what the process is going to involve, what's going to happen, when it's going to happen, what they should expect of us, and equally what we expect of them as well. So it's important to provide them with some sort of guidance as to what the claim is going to involve at that stage. And then, we have got to deal with those concerns that clients have. All clients are different. They don't all have the same concerns, but usually clients will have some financial concerns. There might be some real pressing financial issues about, they're not going to be earning over the next few weeks or months. What do they do? How do they pay the mortgage? How do they pay the bills? How are they going to meet some of the expenses which they know are going to come their way? Whether it be buying equipment or trying to pay for care or making some adaptations to their house. And these are all the concerns that they have. They're concerned about, their family having to help with their care and what impact that's going to have on other family members as well. So these are the concerns that clients often typically have. So these are the things which I'm having to think about at that initial meeting. And then obviously we're also having to think about the legal case as well as the pragmatic, practical considerations. There's also how do I progress this from a legal standpoint as well. So you're having to think about gathering evidence and working out who do you need to speak to from a witness point of view. Do you need to liaise with the police? Do you need to speak to the health and safety executive? Do you need to try and make sure that evidence is preserved, whether that be vehicles or mobile phones or CCTV footage? So these are the sort of thoughts that are running through your mind as you're sat with that client trying to work out, well, what are the to-do list tasks that I'm going to have to take away from this meeting, both from meeting the client's needs, but also progressing the case as well. And I think another really important consideration is to, obviously with the client's consent and assuming the client's happy to do so, to involve the client's family in this initial meeting, to take them along with you as well, because the client doesn't really know you at that stage. Yes, you're going to try and build that relationship with the client, but they don't really know you. And so they may have concerns, they may have questions, the family may have questions as well. And if you can deal with those at that early stage, it makes things less stressful from the client, because otherwise the client's going to be having to field these questions from their family members and may not know the answers. But if you can involve the family at that initial stage, then there's a good chance that the entire family, including the client, go away feeling a bit more reassured, a bit happier with what's going to happen in those preliminary stages. So a lot of that initial client meeting.
And I think that's an interesting point as well, Dan, because from a practical point of view, it's often really useful for us and for treating teams and for case managers to know the family, because a lot of decisions that have to be made during the life of a case are extremely difficult, and sometimes the claimant is so close to things. It's really useful to have other family members as a sounding board to support them. And after we have a meeting with them, which is daunting for some people, they can go away and speak to their family members about it. So I think that's a really interesting point. And all of the concerns that we touched on there, I think bring me kind of nicely into the next question that I have for you, because a lot of those concerns, like adapting the house, purchasing equipment, a lot of our clients aren't able to return to their pre-accident homes at all. And finances are a genuine concern for those people. And I suppose I wanted to talk a little bit about interim payments, because when you have a good interim payment at an early stage of a case, it makes things easier for the family and for the client and alleviates some of that stress. How common is it, and how easy is it to elicit an early interim payment generally?
At that very early stage, it's actually quite rare to get an interim payment, or certainly a sizable interim payment. And that's not because defendant insurers are being naughty or in some way being obstructive. It's because they've got their own job to do as well. They need to investigate the claim. They need to speak to their policyholder. They need to try and get a grip on what's happened with the accidents. And they're unlikely to release very substantial sums of money at a very early stage. They may release some ex gratia payments, you know, £10,000, £25,000, something of that order, to alleviate those immediate financial concerns that clients have. But the sort of size of payments you might need to adapt a home or purchase a home, or even to put in place, you know, a settled care regime, they're pretty unusual at that very, very early stage. You might get them a number of weeks into a case, but in that very early stage, quite unusual. And as I say, that's not because defendants are deliberately being obstructive. It's because they've got their own job to perform as well. I mean, they might have a policyholder who's being uncooperative and they just can't get a version of events.
Yeah.
It's that our own client has no memory or recollection of the accident, and we ourselves don't know what the case is going to be. We just know that the client was involved in an accident and the defendant's vehicle was registration number, whatever. And so we put the insurers on notice. We may not even know what our allegations are going to be against the defendant. So, you know, unusual to get a sizable interim payment at that stage. But of course, an interim payment isn't the only way that we can fund the needs, the immediate needs that our clients have. You know, there are other ways that insurers can go about putting their hands in their pocket. Yeah,
which is slides me nicely into my next question, which is is it your experience that defendants generally are keen to contribute or in some way be part of the claimant's early rehabilitation by agreeing to commission an immediate needs assessment under the rehab code?
Yeah, I mean, I think there are very, very few cases now where insurers don't at least consider an INA and thereafter funding the reasonable recommendations in the INA. I think the only cases are cases where a defendant has an early view that there's absolutely no way that they're paying anything out in this case, that this is a case where the claimant is completely at fault. But even in some cases like that, insurers are still prepared to to fund some things, certainly to fund an initial INA. I mean, from my perspective, there's little point in us agreeing to our client taking part in an immediate needs assessment unless beforehand the insurer has provided at least an in-principle commitment to funding the reasonable recommendations as set out in the INA. Not asking the insurers to say beforehand they're going to be bound by the recommendations, they have to fund every recommendation, but at least for them to show willing that provided they think a recommendation is reasonable, that they will fund those recommendations. And then of course, you know, why wouldn't our client take part in that process, because it's only going to be to their benefit.
Yeah, I'm trying to exclude the possibility that the defendant just use it as sort of an information gathering exercise, which is unusual, to be fair. But I suppose it's an interesting thing to think about in the early stages, and as well, it you know, it's not directly relevant to claimants necessarily, but it does have an impact upon them. Their end result is that the relationships that whatever solicitor you choose, it's always beneficial to the client eventually for your solicitor to have a pretty good working relationship with the defendant as far as that is possible, because these issues are so important, and it's never, there's not a downside to having a good relationship with them. But I want to move on a little bit and talk a wee bit about case management. Time is running away from us, as it always does in these sessions, Dan, but we'll touch on it quickly. In terms of case managers, what are the key considerations in deciding who might be a suitable case manager? And what happens if we know the case management is necessary, it's required, therapy is required, but there's no money there, the defender refusing an interim payment?
Well, I mean, there are a number of very simple points. Clearly, the case manager's got to have real experience and expertise in that particular injury type. So there's no point bringing in a case manager in a case involving a very serious brain injury if they've got no experience of brain injury work. So that's kind of a given. They need to have real experience and expertise in the particular injury type. And, you know, and you know, a case manager I might recommend in a brain injury case might not be the case manager I'd recommend in an amputee case, for example, because there are sometimes some discrete issues in cases that certain case managers have particular expertise in. So expertise is clearly a major consideration. Previously, I would have said geography is a major consideration. You know, we used to try and find case managers that were fairly close location-wise to our clients, and that's still an important consideration. But as we've all got more used to dealing with Zoom and FaceTime and other video platforms, that's less of an issue now. It's still a consideration because there are still going to be a number of face-to-face meetings, and it's likely that case managers who are geographically close to a claimant will have a better understanding of the resources that are available in that particular part of the country, will know who the best treating physios or treating OTs are going to be in that part of the country and can bring them in. But geography perhaps less of a consideration than it was a year ago. And then the other thing, and this is almost that intangible quality, is who do I think is going to work particularly well with that particular client? And just as it's important for a solicitor to be able to build that relationship of trust and to be able to establish a rapport with a client, of course, it's just as important for a case manager to be able to have that relationship as well. And sometimes you get a sense that a particular case manager might work well with a particular client. Sometimes you don't always know, and clients will want to have what's called a beauty parade. We'll want to see a number of case managers, maybe see 2 or 3. And it may well be the client's done exactly that with their solicitor as well. They've interviewed 2 or 3 law firms before they've made the decision. And so that's something which we often ask case managers to do, to have a kind of a free, no obligations meeting or Zoom call with a claimant, so a claimant can, you know, get the measure of them, if that's the way of putting it. But to ask the final point you made, which is about what do we do if no interims are available. There have been occasions where the case managers that we trust and who equally trust us and trust our judgment, and where there are cases where we're very confident that the case is going to be successful, or where we're confident an interim payment is going to be forthcoming in the not too distant future, where we have asked case managers to work on a kind of a deferred payment scheme, to submit their invoices, but to be aware that we might not be able to pay those invoices for, you know, a month, 2 months, 3 months, maybe even in 6 months' time. And, you know, those case managers that trust us and trust our judgment have sometimes, in the right case, been prepared to do that. And that can make a huge difference to that particular client's life, bringing a case manager in from the get-go rather than waiting until those funds are available on tap. Yeah, for sure. And I suppose from a practice point of view, Dan, for any case managers that have joined us today, it's useful for case managers to be entirely clear in their CVs about exactly what their specialism is and how recent their experience is and the type of cases that they're currently dealing with. And that'll give the client a really good flavour of you know, the type of work that they do, and having those early conversations, of course, about the options if there isn't any finance in place and all of those sorts of things. But we're at 19 minutes now, Dan. We nearly did it, but not quite. So I'm going to wrap us up, but thank you ever so much, Dan, for kicking us off today in this mini series. We've got part 2 next week. We've got Ben Townsend, another partner from the PI team, and Ben's going to be talking about documents which make the world go round in these cases. So document preparation by case managers, by MDT members, how those documents are used in the litigation process, what our process of disclosure is, and just giving you a little bit more insight into that side of things. So do tune in next week. You know the time, it's 1 o'clock next Wednesday, as always. Invite to follow, and we look forward to seeing you again. Thank you so much. Thanks, Dan.